Welcome back to the Torchy Blame series. In this, the new year of 2022, our first segment, which of course is to discuss the order denying the City of Northport's motion for rehearing regarding the deannexation, meaning the deannexation is going forward very quickly. And before we begin, of course, again, today I am your host, Cheryl Cook, and I want to welcome our newest members of the Torchy Blame series roundtable. And we're going to do this piecemeal, little bit by little bit, because we just are exhilarated over this item because it's giving us a lot of ammunition to back up what we have been saying, and I have been saying, Cheryl Cook, on my many platforms since the quote new quote government in the city of Northport in November 2016. And we've called it at different times the utopian government, the sovereign citizen government, the scammer government, and they're all one and the same. And now we have a court actually telling us that we have been correct. So let's go right into this. And here we see, right off the bat, first paragraph, and besides, by the way, this is 5 pages. Before the court is respondent, meaning the city of Northport, and that is under, keep in mind, this is all under the guidance and supervision and direct involvement of Amber Slayton, the city of Northport's city attorney. The city's corrected motion for rehearing. The court requested a response. Petitioners, that's the West Villagers for Responsible Government. Petitioners responded. As the rehearing motion is an improper re-argument, the court denies the motion. Okay, Judge Hunter Carroll could have stopped there, couldn't he? All he was required to do was either grant or deny the motion. But he didn't do that. He took time to go further and tell the city what they did wrong. The court writes to address further certain of the city's arguments. So we have already laid the groundwork for what we look for in different documents of this court, in particular, in this case, even more specifically, which is the deannexation. And keep in mind, at this point, all the city should be almost obsessed with is how are they going to undo the damage that they've done in the past 4 years plus since November, I think it's November 22nd, 2016, and even before that with the Linda Yates, Jackie Moore, Tom Jones vote to approve the $14 million pool. That was September 2016. How is, moving forward, the city going to remedy the damage that they've done? Because now they no longer have the cash cow to rely on. This is going to kind of continue a little bit longer, but at some point, whoever is sitting in City Hall and their city manager, whoever was elected, is going to have to clean up the mess that has been made, and we're going to name all the individuals by Linda Yates, Jacqueline Moore, Tom Jones, Miss Debbie McDowell, Vanessa Carasone, Chris Hanks, Jill Luke, Pete Emmerich, Alice White, and even Barbara Langdon. All because continuing on any kind of government activities now, these electeds, your electeds, have to take into consideration they're losing an enormous amount of not only money, but reputation, because this will become a national issue, this case. So let's get back into the judge's order. Okay, the court has already denied the city, Amber Slayton's motion for rehearing. And now let's get into these bench slaps. And if you're going to hear paper ruffling, it's because we have already gone through this and highlighted what we thought was the most humorous. And we're not saying humorous about the judge, but humorous that this is even continuing the challenge to the deannexation, because we're going to lose. We, being the city of Northport, are going to lose At this point, again, this is nothing but a vanity project by the 5 people that are elected to office. And then, of course, you get into issues as to whether they're being fiscally responsible to continue this, because they're going to lose. And mostly also Amber Slayton's reputation, because this is going to follow her. We guarantee you this will follow Ms. Slayton once she figures out that she is no longer going to be able to gouge you and me, the taxpayers of Northport, with her employment. Okay, interestingly, now that sets up Amber Slayton for a bench slap. The city, in its rehearing, sidestepped the court's conclusion. And then the court, now keep in mind, the court has to go back, reread his conclusions. This order, even though it's 5 pages, this order took a lot of time for this judge to sit down and write. And what's also interesting is the expediency with which he entered it. Usually court orders take a month, 2 months. We're looking at this lawsuit against Chris Hanks and the city. This is from May. It was handed over to a magistrate, and it's still hanging out there. We can't get how much we have had to pay for this ludicrous lawsuit, in our opinion, against Chris Hanks and the city of Northport, because it's still open, and there's been no activity since May. So this judge, Judge Hunter Carroll, in the de-annexation issue, worked over the Christmas holiday in order to quickly enter this order denying the city of Northport and Amber Slayton. Okay, so interestingly, and then we're not going to get into, this is the support of what the judge, this is the rest of this is, and we're only going to explain this once, the rest of this paragraph or this sentence is to support his bench slap. As the city continues to fail to address that fatal flaw, the rehearing motion is due to be denied. Now this is heavy, heavy language coming from a court. The city is continuing to fail to address a fatal flaw. A fatal flaw. In other words, are they too stupid? Is the city too stupid to understand what the court addressed in his previous order? Or is the city, Amber Slayton, is she just going to try to bully the court into a different order? Instead, the city, in its rehearing motion, continues to seek the court to rewrite the section process to make it more economical and less time-consuming for the city. This is major, major language hitting out at the city. This isn't a bench slap. This is a judge pissed off. Neither the court nor the city created this multi-step process. The legislature did. If the city would like to see the process changed, the city's relief lies with the legislature, not the court. But wait a minute, we presented in our ERA resolution issue or segment that the city commission doesn't like their legislator. They don't like James Buchanan. That's why they brought in Margaret Good, the Democrat, to come in and help the city commission. So now you've already got the city commission isolating themselves from their legislator, not speaking on behalf of James Buchanan. I'm sure he would still reach out to the city. That's his job. But so now you have the city of Northport under the Utopian Commission, or the new government, slapping at James Buchanan, isolating themselves from their own state representative, which is James Buchanan, reaching out to somebody, Margaret Good, who only served 1 2-year term, and now they're trying to do the same thing to the judge, is override the judge, and the judge telling them, you've got to go to your state legislature. He says the legislators, but it's got to be your legislator that enters the item to be heard for the rest of the state. And then we're going to get into Florida Constitution. We're going to save that for a little later. So going into the next paragraph, and actually this order is 4 pages. The 5th page is the mailing list. As explained in the court's opinion, the legislature created a multiple-step process the petitioners and the city must follow with respect to contraction of municipal boundaries. So, in other words, the court had to, after the fact, school Amber Slayton as to what the appropriate steps were in contraction or de-annexation. The section 171.051 parenthetical 4 step properly would include the consideration of whether contraction should be done. The city's efforts to compress those steps is improper, and it also avoids the public notice requirements. That must occur before the commission may conduct the hearing. Now we're going to get into, and we presented it before, public notice requirements. Now what's important about this, we're going to bring you an enormous section or segment regarding public notice requirements. And the reason I'm going to really focus on that section is because, remember, we have been talking, especially me, Cheryl Cook, on all of my platforms, I've been talking about the illegal methods that the new 2016 government, and even going back to that the last-minute pool amendment of Linda Yates in September 2016, but most specifically, activity of the November 2016 new government in Northport, complete illegal activities over a month and months time frame. So we're going to get into this public notice requirements because now this is a huge issue in the de-annexation process. And again, we are on page 2. We didn't want to roll it up. We wanted you to be able to follow us. Okay, so here's page 1, and we just finished this paragraph. Now, the genius of section 171.051, again, that's a state law, is that it permits a technical review of whether contraction is capable of being done before heightened public notice for a full further hearing that would include considerations of whether contraction should be done. Now, what's interesting about this particular paragraph, go back to that public-private partnership ordinance that we put up, and there's a lot of language in this particular paragraph that the judge wrote that you can challenge that public-private partnership ordinance about, and using the judge's own idea. Now, we're going to move quickly from that because we're not going to leave you hanging. We'll address that in the future as we promised in the past. What is really interesting about this, another thing that's interesting about this paragraph is they talk about, Judge Hunter Carroll talks about layers. First, the genius of this section is that it permits, you can review an item, and we're going to make this generic. The judge indicates, or he insists, because he wrote it, that you can go, that there is a layer system of government, of scrutiny, of practice, not practice, but of policy that your government should be going through. And again, this harkens back to that public-private partnership ordinance, and that's why we started going through it and got bogged down in technicalities that we hadn't worked out before we presented it to you. But what he's saying is, and what the city followed to some degree in that particular ordinance, is that there is a layer of policy decision making. So what he's saying here, and you can read it for yourself, is that you can scrutinize, a government can scrutinize a certain policy or a certain activity before they move forward. And they can either decide at one point that, yes, the item can go forward according to Florida law, which, of course, the city of Northport does not follow in its current genesis, or they can, or the city can, and if they move forward, there are rules. It's just really evenly strictly laid out. Here are the rules, here are the steps. But again, that's law, and the city of Northport does not follow the law. And that's what this is. I'm kind of rambling on this because it's just so astounding to me that this court is so focused and that he understands the duplicity of what the City of Northport elected board and Amber Slayton has been doing since they have come into control of the city. So the next paragraph, which we have not flipped the page yet because we want you to be able to follow what we're talking about. This entire paragraph is one big long bench slap. And it's the Judge Hunter Carroll, having to explain himself again to Amber Slayton. And this is in anticipation of, he's actually talking to the appellate court in Tampa, because your electeds, probably with the guidance of Amber Slayton, who of course is trying to puff her resume so that when she goes to her next job, if she gets a job, and if she ever leaves the city of Northport and her enormous salary that we have to pay while not living in the city of Northport, even though the charter that she helped write dictates she has to live in the city of Northport. Putting all that aside, they have already decided, they being the people that you elected to office, they have already decided that you are going to continue spending your money for this vanity project and to protect Amber Slayton's reputation, which is not going to happen. We guarantee you that. And so that's what this next paragraph is. So we're not even going to go into it. And here is the court disagreeing with the city's assertions, and the city fundamentally misreads the court's order. That is a bench slap. This is a supporting paragraph with the judge having to, again, explain itself, and this is the bench slap. The city fundamentally misreads the court order. A review of the court's opinion belies the city's current contention. And now Amber Slayton has pissed off the judge. Nothing in bold, italicized, nothing in the court's opinion limited the subjects of the commission's review to only the criteria. The opinion did not state that, and that argument cannot be implied fairly from the opinion. Implied, in other words, gaslighted. So now you have a court standing up to a bunch of scammers, your government, the city of Northport, and we're going to specifically focus on Amber Slayton and your 5 electeds, Alice White, what's her name? Miss Debbie McDowell, Jill Luke, and Pete Emmerich, and Barbara Langdon. All tried to imply, meaning gaslight, the judge, and he's not putting up with it. And nor will the appellate court, and nor will the Supreme Court, because that's where this will end up. And you, dear citizens and taxpayers, are footing the bill. And by the way, we did get a word about Jill Luke. Apparently, we didn't speak to Miss Luke. Most of us here at the church, I certainly have not spoken to her or any of these goofballs that are in office. But apparently Ms. Luke intends to move out of the city and move far away from the city in less than a year once she's term limited out. So the damage that she's doing when she's crapping all over you, which is what she's doing, all that damage she's going to walk away from. And we will, I guarantee you, follow her. Not to stalk her, let's be clear, but to make sure that everybody where she moves understands what Jill Luke did to the taxpayers and citizens of the city of Northport. And by the way, to the regional environment, it was Ms. Luke who pulled Miss Debbie out of South Florida Regional Planning Council because Ms. Debbie couldn't stand the scrutiny and was making a fool of herself and didn't want to spend time. In case you remember, she wanted to go to California for 5 days for $5,000 of your money. That was more important to her. So Miss Luke did not only help destroy the city of Northport, but she is clearly responsible for helping destroy the good works of the RPC, which included, as we pointed out, the opium task force that RPC is engaged in. And we'll get into that discussion again later, because what this woman did to you, the citizens and the taxpayers of Northport, and to the most vulnerable creatures of the state of Florida, especially in this region, is incomprehensible. And we will help you try to comprehend what she did in future sessions. So here we go again, another piss off by the judge, but that does not mean the commission can only consider the section of the criteria. The court never stated or implied this in the opinion. The court cannot and will not chronicle appropriate feasibility considerations. The court's limited role is to review what the commission did, not to give an advisory opinion of what the commission could do. If the court were to do that, the court would exceed the proper bounds of its limited review. Now, the only thing that we can, not the only thing, but right off the bat, what we saw in this paragraph is if your Goobers and Amber Slayton decide, remember what the order was granting the certiorari. There were two steps the city can take at that point. One is to either go through another hearing, or number two, grant the de-annexation. So they decided to do neither. They're going to piss off the judge. And if the city, they're trying to find out, what they're doing is probing the mind of the court, of the judge, Judge Hunter Carroll. Because what this particular paragraph tells us is that they're fishing, the city, Amber Slayton is fishing in this rehearing for, if they went back into a rehearing, the city, what would the court be inclined to decide before the hearing? And that's what he's talking about. They're looking not to give an advisory opinion of what the commission could do. So that's Amber Slayton trying to find out. And by the way, we have heard on many occasions that Ms. Slayton is constantly on the telephone to other attorneys trying to find out what she should do. And this kind of actually underscores what we've been hearing. If the court were to do that, the court would exceed the proper bounds of its limited review. So that's the trap that Amber Slayton is trying to set up for Judge Hunter Carroll. She's trying to get him to talk. Talk. Remember, that's what these individuals, the utopian government in Northport, is all about. Let's just get up there and yak. And that's what they're trying to trip the judge into doing, is give an advisory opinion, and then they could challenge the judge's order, they being Amber Slayton, to the appellate court. And so here's the judge making sure that he clears his name of this despicable activity of Amber Slayton. Excuse me. At this section, at this step, the commission must apply the correct meaning to feasibility. What the commission may not do, and discussed in the opinion, is to ascribe a much broader and incorrect definition to the term feasible to justify policy-type decisions of whether something should be done, which essentially would make the section meaningless, this step meaningless. A loss of revenue, increased emergency response time, and the bulk of the other evidence presented to the commission do not speak to whether contraction can be done. Instead, those are value judgments of whether something should be done. Remember what we call this the utopian commission. We'll call them a commission, but they're not. The elected boards with their pajama games and coffee clutches on the dais, we call them a visioning group of people. In other words, what they want to do, doesn't matter what the laws are, doesn't matter what's good for the people, the environment, the betterment of humankind, none of that matters. It's what they want to do, their vision. Everything about the utopian government in Northport is all about visioning. But this is what the judge is saying. Instead, Those are value judgments. Those are visioning, making all these things up, not following the law. That's visioning of whether something should be done. And that's not what the Florida legislature decided. That's not what the laws are. Not whether it should be done, but whether it can be done. So again, they've overspent. They went on this frenzy of massive overspending for discretionary items like the pool, the Brave Stadium, imposing growth vegetation, that vegetation ordinance. We're going to go over that too in the future. All the things that these individuals wanted to spend your money on for no reason, that is now coming back to bite them in the ass, because now they're having to pay the piper, they're having to pay the bills, and they don't have any money. That's why myself, I live east of Toledo Blade, so I'm way out in the hinterlands. I want to see this de-annexation, because as long as that cash cow is sitting there with their big bucket of gold, waiting for your electeds to abuse the money, our taxes are going to go up too, because when they have, and as you saw in 2019, because of their massive overspending addiction, all 5 of your electeds, and I don't care that Ms. McDowell or Miss Debbie voted against the budget. That was a game she plays. In other words, she likes to spend the money. She just doesn't like to have to pay for her spending. So all 5 of your electeds overspent by September 2019 were intending on raising taxes massive amounts, and that's when West Villagers said, we're done with you. And we should all be grateful for them, because now our taxes won't increase, because maybe the spending will, addictions will come under control, or the people will decide to vote in more professional electeds to get the city back in shape. And we're going to talk about a possible candidate, which is why Miss Jill Luke is attempting to redistrict the section she's trying to redistrict. We're going to talk about a potential candidate that she's probably trying to help for future. We'll get into that in the future. And so we're continuing. We're on page 3 of 4, so we're almost done here. And again, we are just so thrilled that all of this came up, because it validates everything that I, Cheryl Cook, have been saying on my various platforms for the past 4 years plus about the illegal activities of these individuals. And I'm just absolutely amazed that almost everything I've been talking about is coming up in these orders. So I'm just an individual quite thrilled. Contrary to the courts, and this is again page 3, contrary to the city's suggestion, the court in its opinion considered the construct of the entire text and the context with the balance of the contraction statutes. And the court did not read feasibility. Okay, so this is the court. We did, of course, highlight some of this, but okay, that is the court defending itself. The city's expansive reading leads to an absurd result. This is massive wording by a state judge. Massive wording. The city, in its rehearing motion, also contends the court did not constrain itself to the appropriate limited review. The city argues the court of conducting a fact-finding expedition and not limiting itself to its proper role. Tellingly, though, the city cites no provision within the opinion in which the court found any fact. In other words, Amber Slayton is slinging crap at the judge. It's not slinging mud. This is much worse. This is just an awful, awful order against the city of Northport. This is just despicable activity by Amber Slayton against a sitting judge. And remember, Amber Slayton came here from Texas, and she was hired from some organization in Sarasota to be an assistant to the city attorney. And she was promoted to her position, and now you know why she was giving those massive raises, because she's willing to sling mud at a state judge and spit in his face on behalf of your electeds. And is any of your elected speaking out about what she's doing? No, they gave her a double raise. And that was just a couple months ago. This is just abhorrent that this is happening to us, the taxpayers and the citizens. The court described the limited scope of its review and then applied that limited scope faithfully throughout the opinion. This is so sad that this honorable individual, Judge Hunter Carroll, has to defend himself from the crap being thrown at him by Amber Slayton, with her massive raises and her refusal to move into the city to be near the people she supposedly represents. Again, the judge has to, after having Amber Slayton sling crap at him, and you can see as you follow this down, we're not even going to chronicle what we have talked about, or maybe we'll put something together and do a chronology of what Amber Slayton has done to this judge. And remember, our reputation, us, the citizens and taxpayers, is on the line with all of this. This will become a national issue. The city also faults the court for not detailing the other testimony and exhibits. Certainly, the court could have identified in its opinion the testimony and exhibits such as Chief Titus and others discussing response times and mutual aid, the expected loss of revenue, and the like. Again, though, none of that evidence addressed whether contraction is capable of being done. For that reason, as explained in the opinion, such evidence is not competent to support a non-feasibility finding. Boy, he really shoved it up their ass, didn't he? Also, make sure you go back and read that affidavit of Sheriff Hoffman, the unsolicited affidavit. He got pissed off too, didn't he, against the city, and actually against Chief Todd Garrison. The city's motion for rehearing is denied. And that's the end of that. The rest of this document is a mailing list. Look at all the people we are paying. This is a huge legal bill you and I will be paying. In other words, the spending addictions that I described in my 2020 mailing when I was running for office, the spending addictions have not stopped in the city of Northport. And there we have it. Thank you for joining us.